Yes, you're listening to ABC Radio Adelaide, South Australia and Broken Hill. Well, I tell you what, we go from one extreme to the other here. Speed dating for the over 60s, looking for love. And now I guess if love hasn't proven to be that successful in your life and you're going through a divorce, how do you make sure that you are protected and get all that is owed to you? And I don't mean more than what's owed to you, but the half that is yours, or whatever proportion is fair under the circumstances. We know that there are many and great deal of efforts gone to hide a lot of the assets of families or relationships. How do you make sure you know exactly what's going on that front? Eva Bailey is a partner with Anderson's Solicitors, focusing on family law matters. Hello, Eva.
Good afternoon, Sonya.
Is it easy to uncover these details, or is it easy to hide assets so that others, particularly your ex, don't know what's going on?
Look, certainly people do try to do that in some instances. Obviously, when people separate, they just don't trust each other anymore, understandably, and sometimes they are hiding or not properly disclosing their assets, and in other cases, the spouse suspects that, but it might not be the case.
Now, the laws that are in place now, is it getting easier to track down those assets?
Look, it is. We do have ways to find people's assets, and part of that is the duty of disclosure that's required under the family law rules for each party to disclose all relevant assets by way of documentation. The federal government's also looking at some changes to enable it to be easier for us to find superannuation entitlements of the other party as well.
Because that was something that you could perhaps hide a little bit because it was details you knew about and you knew about alone. But I'm guessing with these increased reporting details to the tax office that your super is probably a bit more of an open book.
That's quite right. In fact, we have our own clients using the MyGov linked to the ATO to find their own superannuation entitlements, which is important for us to properly disclose to the other party. And the government is changing the legislation so that we might be able to get an order from the court or seek a form through the registry that will also enable us to get the other party's super the same way.
How much of the problems that we have are that you don't know about these assets at the beginning? I mean, is there a point at any point during the breakup, the resolution, the dividing of assets, that these assets can be uncovered?
Yes, look, it's important that people do collect their documentation early on in a matter. It's the fact that sometimes one party runs the finances of the relationship and the other party really doesn't know what's going on, so that makes it difficult. We do tell people right at the start of their matters that they should contact their bank as one of the first ports of call to talk to their bank. Banks are familiar with these situations and they can help them to stop accounts or put limits on accounts, or both must sign on accounts and things like that to protect their assets.
Well, even if there are two names on an account?
Well, in some cases you've got net banking, and if you've both got access to net banking, then either or can often access an account and withdraw some money without the other person necessarily knowing. So it's good to check that out with your bank and change those things potentially if you need to at the time of separation.
Eva Bailey, when it comes to all of this, you said banks are very well aware of these situations, but once a separation has happened, what privacy issues are there around these kinds of questions, information requests?
Look, it's true. The banks can't talk to you about your spouse's details, save for on a joint account, and the banks are well aware of that sort of thing. As I said before, the other party has a duty of disclosure. They have to disclose all bank accounts in their sole name and joint name and provide bank statements. And in the cases where they won't do that, we can subpoena the banks to obtain their bank statements.
So what happens if after all the dividing has been done, it's discovered that someone has hidden an asset that wasn't known about at the time? Do you still have a claim on that?
Look, we do have cases where that happens, and the answer is you do. It's important that people properly disclose their assets, because if they don't, a person can apply to the court to have their property order set aside and seek a greater share of the asset pool. And if the court finds that someone has deliberately hidden assets, they may well give the other party a greater share than what they would have otherwise received.
You're listening to Eva Bailey. She's a partner with Anderson Solicitors. Do you have a question about the division of assets, the hiding of assets, and how you go about making sure that you get, I guess, what is owed to you? No more, no less, but what is owed to you? 1300 222 891. You can also text through on 0467 922 891. What are the legal things that are really important to put in place so that, because I'm guessing when it comes to assets too, do liabilities also come under that banner? Debts,
Yes,
liabilities?
Important. That's right. It's important to have a look at your debts at the time of separation and make sure again that people can't be increasing mortgages or overdrafts, line of credit and things like that, big spending on credit cards. We can in some cases add back those assets to the pool if someone is proven to have spent money that then is attributed to being part of their property division. But it's better to stop those debts being increased rather than try to track the money later.
What are some of the instances you've seen where perhaps assets have been hidden or withdrawn or taken out that have become a matter of dispute?
Well, there's been some cases certainly through the courts, and there's been a case in 2015 where one party withdrew a cheque for nearly $700,000 from their bank account. And
you'd kind of know that was gone, wouldn't you, Eva?
Well, you'd think so. And look, in that case, the other party did know it was gone, but the person who took it out refused to divulge it, refused to rebank it, refused to explain it. And ultimately, the other party got a subpoena from the bank, showed it on bank statements. The court actually ordered that cheque be cancelled, placed back into the account, and the court then ordered a greater share to the person who had been wronged in that action.
So if you are deliberately hiding assets, you might be penalised through a reduced amount in the eventual division.
That's right. There's a few ways the court can punish you. They can give you a fine. They can find that you're not credible in your case. They can dismiss your case. They can order some legal costs against you, that you pay the other person's legal fees. And in the most serious cases, yes, they can award you less from your property division than they would have otherwise given to you.
We'll ask more questions in relation to hiding assets in family law matters and how that might impact you. But you might have a question for Eva. Feel free to give us a ring, 1300 222 891, to ask something more specific. You can also text through on 0467 922 891. Anne is at Noarlunga. Hello, Anne.
Hello. I had these friends a few years ago that separated, and they had adult children. They drew everything up themselves on a document, changed the title, whatever, because their house was freehold, signed this document. They never got divorced and didn't go through the family court because they didn't think they needed to because the children were adults. About 5 years later, one of them got retrenched from work and got a fairly large payout. The other one took them to court and got $100,000 of the payout, and it cost that first person $30,000 to fight it. How is that fair when they've written it all up and it's 5 years later, after they separated, he got the payout?
That is a good question. Eva Bailey.
Yes, look, I agree with you, Anne. That certainly seems unfair, and I don't disagree that it perhaps is. What we tell everyone is it's absolutely essential that you have your property settlement formally recorded, because otherwise that can happen, and we have seen it in cases where it's even more years later than that. So it's important to have a proper consent order drawn through the court or a proper binding agreement. Otherwise you can come back later, and often people spend the money they get out of their property settlement and someone else does better, and then the court feels that they still need to make some adjustment, and it does cost people a lot of money going through the court system. So you definitely need to have it formally recorded in order to protect yourselves and the other party.
So it wasn't that they hadn't come to an agreement, they just needed to formally have that recorded for that to be the end of the matter.
That's right. Eva. It sounds like in that case they drew it up themselves and they had a record of it, but the Family Law Act says that it is not legally binding unless it is recorded in a consent order or in a binding financial agreement. And in theory, parties can do a consent order themselves, but it does involve filing documents with the court.
Okay. Eva Bailey is a family lawyer, or a lawyer specialising in family law. John, you've got a question for her about assets that are hidden?
Yes, Eva. I'm going through a case at the moment. I'm going into court. I'm not in court yet. I've had court orders produced against the other party for bank statements. And they've got another bank account somewhere that shows a withdrawal of $8,000 under savings. And so that's going somewhere, but the other party won't produce it, even under a court order. What can you do about that?
Yes, that is tricky, John, because we can subpoena banks, but if we don't know which bank to subpoena, it's difficult. You don't want to subpoena all the banks because it will cost you a lot of money to do so. What you can do, I think, and obviously I'd have to defer to your lawyer's advice to you specifically, but generally you can bring a further application to the court about the person providing further and better disclosure, and or the person giving disclosure on oath and answering where that money is going, into what bank account. So you can also bring a contravention application to the court if someone's breaching a court order. So unfortunately, it probably involves potentially bringing another application to the court, but the court should be able to deal with that for you.
Good luck, John. Thanks for your call. Look, I've got a couple of texts here. Well, this one says, my dad had to hide some assets or he would have been left destitute due to the woman always getting the most. Another texter highlights this as well, what they think, and that is that women appear to be favoured in the system. Is there any indication that that's the case, Eva?
Look, I do get that feedback a lot from clients and other people, and my view is that the law divides the property in accordance with the Act, and one of the considerations is future needs, and it tends to be the case still that if a woman is a primary carer of children, her future needs are considered to be greater than the husband's or the male's, and that's why the woman may end up with a greater percentage. But divisions based on a lot of different factors, including the assets people come in with and all those things, but future needs and care of children still tends to be something that favours the female because she's often the primary carer.
We're talking about hiding assets when it comes to family law matters. If you've got a question for Eva Bailey, make sure you get in before we finish up with her in the next few minutes. 1300 222 891. You can also text through on 0467 922 891. Ian rang. He says splitting assets also affects vehicle registration. If you have a joint rego, it can be really difficult to split. This isn't about hiding, but just about the reality of the process, Eva.
Yes, it's important that your lawyer who's helping you record your property settlement is aware of the names in which assets are held, because when we write up the orders that finalise your matter, we need to put in there the processes for transfer of title on property, transfer of car registration, etc. So it's important that your lawyer's across all of that so that they can detail in the orders the process that needs to occur to fix all of that up as part of your agreed division.
Eva, you talk about hiding assets, but sometimes I'm guessing there are situations where either assets are spent, frittered away, maybe gambled, whatever. When those assets that were there are gone, do you have any sort of retrospective claim on their value that means you've got an ongoing debt, I guess, from your ex?
Yes, look, it is important to consider the contributions people make into the asset pool as well as what they spend out of it. And if somebody has spent excessive amounts or wasted away monies, then you might have an argument that they haven't contributed in the same way as the other person has. So you might look at adding that asset back to the pool, as I said before, or otherwise giving them a lesser share because of their lower contribution having spent those monies.
Eva, do you think these days, with changes to laws, and I think you highlighted at the beginning of this discussion the changes in relation to superannuation, that is it getting now to the point where it's almost too difficult to hide assets?
I'd like to think so, Sonya, and I think it's too great a risk because you're not protecting yourself in terms of your final division if you're hiding assets. If someone finds out later that you've gone and sold an asset for a lot of money, and people talk and they do find out, then you're in danger of it all coming undone and having to go back to court for another division. But I'd like to think it is getting harder and harder to hide assets. We're always going to have people claiming that their ex earns cash money from their business and that they've hidden it somewhere. That is hard to track, but I think it is getting harder and harder, and the ATO and other organisations, along with the government, are making that the case.
Now, Eva, Kathy's given us a ring. She's in Para Hills. Kathy, good afternoon to you.
Oh, good afternoon. Thank you for taking my call.
What's your situation?
I'm just wondering, my mum and I have purchased a property together, so she's put in her a sort of a lump sum towards the purchase of the property, but she's not on the title. My name's on the title solely, and I'm just wondering, can, say when she eventually passes on, can that sort of lump sum be tracked by other members of the family?
Look, that's a tricky one, Kathy, and I'm not sure that it's family law based. It might be more property law or conveyance based, but it depends on how you hold that property. If you hold that as joint tenants, my understanding is that once your mum passes, the whole property goes into your name. Whether or not they can look back on records as to who purchased it, I'm unsure about that. It would depend on if they have access to her banking records and those kind of things, I would think.
Kathy, you might have to go into a property law about that one to get some more specific advice. And I'll finish up with this one if I can, Eva. This texter says, our family farm is in the middle of a split up of land. He said he'd buy me out. We got it valued, but he's been approached by a wind tower solar company to put wind towers on the farm, but didn't tell me. Where do I stand? I guess this is not so much hidden assets, but hidden value of assets, maybe.
Yes, quite right. I would say that's a valuation issue, and when parties can't agree on the value of an asset, we often need to get it valued by an independent valuer. And then it's important that that valuer be given all of that information, including that prospective value. It's the same for a house that might be subdivided and things like that. You need to have a look at what the value of the asset is and its potential value, and a licensed valuer can do that for you.
Eva, as always, thank you for helping us out on that front. It's something that can cause a great deal of pain, I think, for people as they try to divide up assets generally. And then when things are being hidden as well, makes it very difficult on both sides. Thanks so much for your time today.
Thank you, Sonya.
Eva Bailey is a partner with Anderson's Solicitors as we discuss hiding assets in family law matters.